Welcome, business owners. We are here today to make you feel uncomfortable. Yes, that is what I said. We want you to feel a little bit uncomfortable after watching our broadcasts. And today is going to be really important. Today marks our 17th broadcast, and we are talking about employee lawsuits. I am Dana Ball. I'm a small business attorney here in the state of Utah. And honestly, when I first started practicing law, I used to sue companies for discrimination, for sexual harassment, wage and hour violations, breach of contract. So I've been on this other side, and I've seen how messy it can get when a lawsuit happens to a small business. And I want to give you some heartache so that you think a little bit more about your day-to-day and maybe think about some stuff you can tweak on the decisions you make throughout your day that could really help you in the long run to protect your business. So today, employee lawsuits. We are going to get right in. Is your business, your small business, really at risk of an employee lawsuit? What do you think? What's the answer? Absolutely. 6 out of 10 employers have faced an employee lawsuit. 6 out of 10. It's pretty high. They are expensive, these lawsuits, whether there's valid claims or they end up not going anywhere. It's expensive to defend and to take time out of your day and your business to go through a lawsuit, answering interrogatories, showing up for depositions, producing documents, and having to find all the documents that you need to produce. It can take 2 or 3 years, and it can be extremely stressful and a strain on you, the business owner, your employees, and maybe even affects how you interact with your clients, your patients, your customers, whatever it is, the third parties that you're dealing with in your business. It takes its toll. So think about this. An average out-of-court settlement runs about $40,000. So that's if you're just trying to make this go away before you have to actually go before a jury. It will run about 40 grand. And so that includes your costs for attorney's fees and what you're settling for to get the claim to go away. In addition, think about this. 10% of wrongful termination and discrimination cases result in $1 million settlement. That's a lot. Do you have $1 million laying around? The majority of the cases that end up in litigation and actually go through a jury trial, 67% are ruled in the employee's favor. So you balance it. You decide. Okay? But I want you to really, really think through the claims that we're going to talk about today. And I want you to feel a little nervous and hopefully get on the ball. Face reality. That is our goal all the time. Face reality, business owners. Okay, what are the types of claims that an employee can bring against you as a company and you individually, and name you individually as the business owner? So we have discrimination. So discrimination encompasses a lot. So it encompasses race, sex, age, religion. In Utah, we've got sexual orientation has been added a couple of years ago. Discrimination is where you choose, it's unfair treatment. And we look at comparing like a male versus a female, pretty basic. Or age would be anyone under 40 versus anyone over 40. Okay, another claim, sexual harassment, hostile work environment. I'm not going to get into every single claim and what it entails. Those are going to be covered later through different broadcasts, but we're just trying to run through so you can be clear what is at stake. Hostile work environment. Usually people think that is just a sexual harassment-based claim, but it is not. You can bring a claim for a hostile work environment based on race discrimination, based on religious discrimination. Anything can cause a hostile work environment. and it can be covered as a legal and viable claim to bring against a company. Okay, retaliation. This is really important today. Retaliation has become the #1 frequently cited form of discrimination. So retaliation is terminating an employee who complains of age discrimination, for example, and you take some sort of action against them that they can end up proving that that action was taken in retaliation because they filed a complaint, or they simply just told their supervisor, hey, I think I've been passed over for promotion because I'm 50 and the guy who got the job is only 30. So retaliation is very, very hot today for a claim. All right, other claims: whistleblower, negligent hiring, negligent supervision, negligent promotion, and negligent retention. Disability claims: failure to accommodate, disability discrimination. And then we have breach of contract. So what does that mean? What if you have employees, but you haven't signed an actual contract with them? So how can they sue you for breach of contract? Well, if you have a handbook, go look at that. That can put you in a perilous situation for breach of contract claim if you're not following what's in that handbook. Maybe you have policies that are in writing. There's other ways to prove that there was a contract in place that was maybe made verbally, and the circumstances can support a claim for breach of contract. All right, and finally, invasion of privacy. So maybe you've exposed the employee's confidential information somewhere that you shouldn't be. Now, I work with a lot of business owners that have less than 15 employees. And the law that covers these claims that we just talked about usually requires you to have at least 15 employees. So if you have less than 15, does that mean that you are free to discriminate? That's a question, and it's a legitimate question. Are you free to discriminate if you only have 5 employees? Well, you're not. I would be very, very careful. Tread lightly, because there are still ways for employees to bring some lawsuit claims against you. We call these backdoor claims. If they don't have a Title VII action because you don't have 15 employees, there are other claims that can be brought against you, and just use the same, if it's sexual harassment, they can use the facts to support these other claims. So be careful. That doesn't totally take you out of the water because you only have 5 employees. So other claims that can be brought, and these claims can be brought with the ones we've already talked about, and we usually do. If we're suing, if an employee has filed a lawsuit, that attorney is going to throw every type of claim they possibly can and see what sticks. So these are other claims. So if you have 1 employee, there's a cause of action for race discrimination. It's a section 1981. Wrongful termination is a really common claim, and it's based on public policy, and it's really fact specific, so you really need to get your facts reviewed with an employment attorney to determine what your risk is there. But this wrongful termination claim, it can be a little tricky for an employee to bring because it opens the door to their past employment. And so, if they have issues in the past that they don't want to be brought to light, or they're really hoping to just tuck away and nobody ever finds out about them, they're not going to want to bring a wrongful termination claim against you because everything is open door. They can get your employment records from all past employers. They can, as an employer, you can, find out if they were ever fired from a job and why. Were they a lousy employee and why? So it opens the door if they do have anything in the past that they really don't want to have out there. All right, this next one is a pretty common claim, especially for sexual harassment. So it's intentional or negligent, depending on the facts, infliction of emotional distress. Again, this is one that not too many people have the gumption to follow through and sue on, because again, they're opening the door to some discovery that they may not want out there. You have to open up your medical, your psychological records with this cause of action. Everything. They can request all your health records from every doctor you've ever seen. So if you have any trauma in the past, if you have any abuse, any psychological conditions, diseases, divorces, surgeries, stuff that really you want to have kept confidential, that's not going to be a cause of action that employee will be jumping on board to take. All right, other causes of action: assault and battery. Sexual harassment is a great one to use as an example here, because if there is any inappropriate touching, that can be used as an assault and battery charge. And there is civil actions for assault and battery too. There's criminal and civil. So then we've got tortious interference and other torts that, depending again on the circumstances. So unfortunately, just take a deep breath, because you don't want to end up in a lawsuit that involves any of these claims. It is just messy, simply messy. But unfortunately, many employers are unwilling to commit the time, bear the expense of implementing the right policies for their particular business needs, their particular management style, the dynamics of how they run their office. They simply are unwilling to make it a priority until they've been sued. And so we see a lot of businesses reach out to us because they've been through a lawsuit, or a charge has been filed with the EEOC or the UALD, and an investigation took place and they settled. They've been through it. They don't want to do it again. So it's really up to you, the business owner, to protect the work environment. It is. The buck stops with you. I've said that before. It stops with you. You'll be glad the first time an employee issue arises if you have policies, a good handbook, good systems in place to fall back on, because they will help limit and mitigate the damages that could be done. All right. So one question you need to this is where I want you to really dive in. Do you have a system in place for employees to feel safe to bring and raise concerns that they have about their work environment, about their coworkers? Do you think that if that people don't feel comfortable bringing a concern because they're going to be ridiculed or retaliated against in some way? Do you have a system set up where your employees feel comfortable to do this? A lot of employment issues can be resolved internally. If there's any legal issue out there, then it can get resolved before too much harm is suffered. And that's the key of these lawsuits, is proving the harm. And so if you don't tackle things right away, then the damages go up. But if you can nip things quickly, the harm is minimal. And you're not going to be out as much time and money and emotional distress because of what a lawsuit entails. So, okay, final question to leave on here today. What do you need help with in safeguarding your company from risk? So go ahead, think about that for the weekend. Thanks for joining us, and we will see you next time.